If you have been sued by a creditor, received court paperwork, or have a wage garnishment, you are probably feeling overwhelmed and unsure about what to do next. The real truth is that filing bankruptcy can still protect you even after you've been sued. Hi, I'm Perlman. I'm a consumer bankruptcy attorney. I've been helping businesses, consumers, and families get a financial fresh start for 30 years. Before we talk about what happens when a creditor sues you, I want you to know that reaching out to a bankruptcy lawyer does not mean you're filing bankruptcy. It simply means you're trying to understand what your options are. If you find this video helpful, make sure to like, share, and subscribe, and contact our office if you have any questions. One of the most misunderstood concepts that I hear regularly is whether you still can file for bankruptcy after you've been already sued by a creditor. And in most cases, the answer is yes. Whether the lawsuit you receive involves credit card debt, medical bills, personal loans, bankruptcy in most cases can stop the case and prevent further collection against you. When a bankruptcy case is filed, the bankruptcy case creates something called the automatic stay, which stops creditor action immediately. This means creditor lawsuits are paused in their tracks, wage garnishments must stop, and bank levies that have been frozen can in many cases be released. Creditors are no longer permitted to contact you once the bankruptcy case is filed unless they seek special permission, which in most cases would be in the form of relief from the automatic stay, which is very rare in a consumer case. If you're being sued and a judgment hasn't been entered yet, the bankruptcy can stop the lawsuit and prevent the judgment from ever being entered. If a judgment has already been entered, bankruptcy can still eliminate the personal obligation to pay the debt, and in most cases, the judgment can still be treated in the bankruptcy. In my experience, a wage garnishment is what often pushes most clients to seek the help that they need. The good news is that filing for bankruptcy typically stops wage garnishments immediately. Once a bankruptcy is filed, your employer is going to be obligated to stop withholding funds once they receive notice of your bankruptcy filing. And in many cases, they have to return what has previously been garnished after you file your bankruptcy. However, that depends on timing and proper legal action in your filed bankruptcy. Most debts that lead to lawsuits are typically dischargeable in your bankruptcy. It's important to know that some debts are non-dischargeable. That includes child support, alimony, sometimes student loans, and certain tax debt. Your bankruptcy attorney can review your specific situation and tell you which debts are dischargeable and non-dischargeable. It's important to note there are two main types of consumer bankruptcies. There's a Chapter 7 and a Chapter 13. Choosing between a Chapter 7 or a 13 after a lawsuit has been filed against you has a lot to do with your income, expenses, and your long-term goals. If you're being sued by a creditor facing a wage garnishment or a bank levy, do not assume that you're out of options. You can still file a bankruptcy. Bankruptcy is a legal tool to stop collection activity and give you a financial fresh start. Remember, contacting a bankruptcy attorney does not mean you're filing bankruptcy. It simply means you're trying to understand what your options are before it's too late. I'm Perlman. I'm a consumer bankruptcy attorney. If you found this video helpful, please like, subscribe, or share with somebody that you might realize needs financial help.